and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
We got one. We got a real good one for you. And here he is. David Whiting is here, Melbourne solicitor, to dispense some free legal advice. 1300 222 774. David, good morning.
Good morning.
What colour's your bedroom wall?
Vanilla.
Vanilla.
It's soft. It's not a hard white. It's a soft creamy white.
Softer white. Very
Yep.
nice.
Mm-hmm.
I am just being spammed this morning with the most amazing photographs of the interiors of my listeners' homes. And the colours are incredibly deep blue, a really deep indigo. There's a charcoal. There's a very, very deep green. There's another charcoal, wonderful brown. Amazing. Just look, and everyone's just saying to me, Virginia, take the plunge, paint the walls dark, use a strong colour, go for it.
Well, last week I reported you talked about the Queen's Gambit,
I did.
the television program, and the house that they lived in had the most amazing floral wallpaper.
Wild
so
interiors.
why would you not take that as the theme?
That's true,
Not
that's the
paint some rather elaborate wallpaper. My mum and dad had wallpaper that was velvet and gold in one room.
Flocked wallpaper,
Yes,
it's called.
yeah.
Yes. I love a flocked wallpaper.
Okay.
Got to be careful how you say that word, though, when you're on
Indeed,
radio.
you do.
David, we don't have any homework to deal with.
No, free and easy.
Got any news for me?
Well, there's an interesting piece of legislation that was announced by the state government last year, but with COVID was introduced in October. It's called the Spent Convictions Bill, and it's fantastic, I think, for certain classes of offences. In fact, for the vast number of offences, when they're 10 years old, they don't count anymore. So if one was to get a police check for certain purposes, then they wouldn't show up 10 years later. Now, sexual offences remain, serious criminal offences remain, so there's classes that remain, but as a general proposition, when you've a certain amount of time has lapsed and you served your debt to society, you no longer carry it. And there are offences for reporting that somebody has a spent conviction, so yeah, I think it's great.
I think it's a sensible thing. Some
Yes.
things it shouldn't be a millstone around your neck all your life.
No, well, the Commonwealth brought it in about 10 years ago, and the state government brought it in maybe 15 years ago for .05 offences.
But this would be broader than that.
Oh, much broader. This is everything. Yep.
Does that mean then, if you went to trial for a particular matter, and of course it wouldn't be brought before the jury, that the fact that you had this previous conviction, but it might at the time, be discussed
Of
at the time
assessing
sentencing.
penalty, yes.
Well, yes, would that,
No,
if it was
it's still
spent, could
it's
it then
spent
be
is
brought
spent.
in? No.
Spent is spent.
Spent is
So
spent.
if you're eligible for the spent convictions, and again, that's not everybody, so murder is always going to be there, then it's another first offence, because it's going to be a long time later,
Yeah.
and one would assume you would have changed over time.
Clearly not if you're back in court.
Boy, I'm just, oh my goodness gracious me. Yes.
I know. I can be rough.
Yeah, you can indeed.
Sorry
Yes.
about that.
Yes.
That's why he dispenses the legal advice and not me. Adrian in Maidstone, good morning.
Good morning, both. How are we?
Well, thank you.
That's good. I just had maybe a quick question, hopefully a quick answer. I live in a block of 4 units, single level units,
Yes.
and there doesn't appear to be a body corporate or anybody who would come in to look after the small garden areas.
Do you have a common driveway, Adrian?
Yes.
All right, then an owners corporation exists by operation of law. What you and I used to call a body corporate is now called an owners corporation.
Owners corporation.
And it exists, and it's required to have your starting proposition is that it's supposed to insure the buildings and have public liability insurance for the common property. It is possible if the units are not one on top of each other, and so there's no overlap of the units, it's possible for you to resolve to self-insure. But as you have common property, you should have public liability policy, and there are a couple of organisations that will offer it for just the common property for not a lot of money. So I would recommend you look at that.
What about maintenance of common areas where there are some large garden beds? Is that the responsibility of the where the bed's attached to?
No,
directly out the front of? Or?
You need to look and see what's common property and what isn't. And in the development that you're talking about, probably 4 units in a row, you've you're likely to be at the situation where everybody looks after the garden outside their place.
Yeah.
But that's an exercise of choice, not entitlement.
Yeah. Okay. Thank you.
Good luck. Thanks, Adrian. Hope that helps. Sharon's called in from Hawthorn. Good morning.
Danny, hello.
Hello, Sharon.
Hi. We are renting, and we have, excuse me, a relocatable pool.
Mm-hmm.
So, excuse me, coughing there. I have, it's bigger than a little kid's toddler pool.
Yes.
But it's one that you pack away each season.
Mm-hmm.
The fencing laws now require that you need a full building permit to fence the pool.
Yes.
But the building permit must be applied for by the landlord. Tenants are not able to apply for that, are excluded from applying for that. So as far as I can tell, that means tenants are effectively excluded from being able to have a relocatable pool.
Without the consent of the landlord.
Well, there's consent, but also as tenants, we can't actually apply for the building permit.
Well, why would you not build into the lease that you're applying for that the landlord makes the application?
We've already been here for a year and a half.
Okay.
And the landlord lives overseas and doesn't speak English.
Okay. Then you're right. The answer would be that the legislation doesn't allow you... Sorry, presumably somebody manages the property. Is there an attorney or someone who could execute
There's an agent. There's a real estate agent.
Yes, but the agent may have some kind of limited written authority on behalf of the landlord.
I don't know.
But that's where I would start. The way you've explained it, accepting it all to be true, you have no right to make an application for the permit.
That's very fun. So what about like the right of a tenant to have whatever the legal term is, the use and enjoyment of the property?
There's a specific law. You're talking about general principles and specific rules.
Okay.
The specific rules outweigh the general principle. So if the requirement at law is that an application for a pool fence must be made by the property owner, then an application for a pool fence must be made by the property owner.
Okay.
Okay.
Sorry
about that. Bad news for you this morning. Anthony is in Mount Martha. How can we help you, Anthony?
Good morning. Mine is a will question. I refer to a situation where a couple married for over 50 years wish to leave all their assets equally divided between their 4 children. However, one of the spouses is in ill health, and they both agree they would not remarry after death of the other. Such eventualities are not unknown. And recently, a relative remarried after death, and the result was that the new spouse had title to all his assets, and his 6 children were more or less disinherited. How could one ensure that under such circumstances the children are not disinherited?
The answer is you don't give it, is the short answer, Anthony. So
Sorry, could you say that again?
You don't hand the asset over. So every now and then you'll have an agreement between 2 parties to make wills in a particular form, often when there's a second marriage. So, and you want to make sure that certain assets go in certain directions, which is what you're talking about.
Yes.
So you have an agreement that says, I promise that after you die, I won't change my will, and if I remarry, I will make a new will essentially in the same terms as the current one, and I'll make sure that I don't dissipate assets. But that doesn't actually stop you dissipating assets. There's no guarantee. So in the scenario that you've described, the wife died, the husband remarried. If he puts his new partner on the title to the property that they live in, well, those assets don't form part of his estate. Is possible to defeat it? The only way that you would be able to go towards avoiding that problem would be, in a sense, to say, in that scenario, that the husband only gets a life interest in the wife's share of the property. But that's often unfair too.
What's the best way of resolving it then,
completely
David?
clear on all that. But if I took this issue to a lawyer who knew something about wills, he would be able to sort it out for us?
The problem you've got is it depends on the asset structure that you have, and there's no guarantee in the outcome. So let's say it's you, Anthony, and your wife dies, so you now own the house and absolutely everything because you were together for a long time and everything was in joint names. You fell in love with somebody else in a couple of years' time and you married them, and you decided that you needed to move to a different house, so you bought it in both names, and you used the proceeds of the sale of your house to buy it. Mm-hmm. Well, the value of that house, assuming you die before your new partner, goes to the new partner when you die. So you're now leaving a smaller estate, and we know that for most people the value of the house is the major asset. So you might die worth $2 million, but $1.5 million of it's in the house. Well, that's now gone sideways. So your first wife's share that she wanted to go to the children now won't.
Yes.
We could make it illegal for you to marry again. Do you think that would work?
I'm the one that's likely to pop off.
Okay.
That's the problem.
Well, then what you could do in that scenario is you could leave your share of the assets to your children, with your wife having a life interest. But again, interest rates at the moment are 1%. Whatever money you've got is going to get a little or no return. And she decides that she needs to downsize. What then happens to the investment that you've got in the house? Who do I want to? I would have thought that you would want to care for your partner before you cared for your children.
Yes.
Yes.
Yes. Yeah.
And we also get to this really interesting question I see when people make wills is, at what point do you lose the ability to deal with your assets and just minding them for your children?
Well, but different families have very different views on that
They
anyway, and you can't dissuade someone when they've seized onto that. I hope that makes things a little clearer, Anthony, but it is a tricky one. It's something that my husband and I are working through now, but what's interesting is that the lawyer sort of is speaking to us in terms of different wills depending on who predeceases who.
Yeah, so for most people it's two wills in one.
That's right, yeah.
Yep.
And a measure to dispose of some assets so that money is actually dispersed to children.
Yes.
Before the other person sort of carries it on to the rest of their life.
Yep.
So you can sort of do it specifically in that way, and I found that a useful instruction.
Yeah.
Otherwise, if you do want to take care of children, they're waiting a long time. Well.
Yes,
touch wood. We hope they're waiting a long time. Shall we all touch wood?
Time. Yes.
Dave in Bayswater. Good morning.
Sorry to bring a tree thing to you.
Oh, no, I love a tree story, Dave. Welcome.
Okay, thank you. I got the neighbour just inside their boundary's got a rather large tree, and over the week the wind's come and knocked two large branches off, so that most of the foliage is now over my side of the fence, and I'm concerned that it's unbalanced. Is there any way that I can ask him or persuade him or anything to come and take the limbs on my side of the tree back to his side of the tree and dispose of them?
Well, you could, if you wanted to, simply push the limbs over the fence. They belong
large
to your neighbour. Then in strict law you have, in strict theory you can run a chainsaw straight up the fence line. And everything on your side of the fence, you can move to his side of the fence.
Yep.
That seems to me to be, it just doesn't work in this day and age.
Yes.
It is possible for you to go to the magistrate's court to get an injunction to require him to get his tree off your property.
Right.
But, I was talking to someone about one of the local magistrates' courts that has a backlog of 12,000 cases.
Yes.
Now, COVID simply made it a lot worse. So can you imagine 12,000 cases is going to take a very long time to hear.
Yes.
So I would probably start with, I'd probably spend some money on an arborist's report, which might report how the tree needs to be dealt with to ensure that it continues to live. And that might be some pruning, and it might give you some estimates of what's required, and then you start the discussion with the person next door.
Thanks very much.
Thank you, Dave.
Okay, good luck. But I mean that most seriously. I always really enjoy a tree story. Matt has called in from Mentone. Matt, good morning. How can we help you?
Yes, good morning, David and Virginia. Thanks for taking my call. Now, my problem is that I'm currently mired in the mental health system, and I'm on an involuntary community treatment order.
Right.
And I desperately want to get off it because I'm not the slightest bit mentally ill. Now, the way that I go about that is I go to the Mental Health Tribunal, and I've got a hearing coming up this Thursday, but I had one a couple of weeks ago, and we didn't get started in the hearing because before it started, I got into a big argument with the lawyer on the board, the board, and about recording it. I wanted to record it using an app on my phone, but he wouldn't let me. Now, as far as I'm concerned, it's my hearing. I'm the patient, and if I want to record it for my personal records, then I should be able to do that.
No, you don't have a right to record it. There's a general proposition. Do they record them themselves?
No, they don't. And they sent me. I asked. They eventually sent me all the policies and a link to the legislation as well. It's a massive piece of legislation, and I didn't go through it with a fine-tooth comb, but I couldn't see anything about privacy in the legislation, no subheading or anything like that.
They're entitled to regulate their own proceedings, and that would include the right to refuse you to record.
Is there no record kept of the proceeding while it's going on? There's no note taker there?
I don't believe so, no. I mean, you can request a statement of their findings.
Yes.
But that's not what I want. And, they sent me the policy, I think that's the right term, the policy documents that they their policy based on the legislation, they said. And in that they said, it seemed like a bit of a grey area to me at best. As far as I'm concerned, it's a slam dunk for me. But at best, just looking at what their own policies say, it
Matt,
didn't
you're
actually...
going to lose. Supreme Court and County Court will allow you to pay for a transcript through an authorised transcription firm. VCAT records all of their hearings, and the process for... you can never get a copy of the recording. You pay for a transcript, which then goes back to VCAT to be vetted before it's released to you. No other tribunal that I'm aware of will allow you to record it, because it needs to be, if anyone records it, it's them and not you.
Can I just ask you, Matt, why you feel the need to record it?
Because I don't trust these guys. I've dealt with them before, and they're terrible. It's a bit of it's an absolute disgrace, and I just want it on the record for my records, so that it's just. I just want a record of it, a formal record of it. Yeah.
Look,
well, if it's your recording, it's not a formal record because it would need to be from the tribunal, and they won't record them. They won't record them,
and they won't let you press record. I guess if you're trying to persuade them, Matt, that you want to get off this community treatment order, then
fighting with them doesn't help.
Yeah, exactly, and going in there mistrusting them from the beginning, even with grounds. I'm accepting you may very well have grounds. Even with grounds, is not going to give them the impression you're hoping to.
I respectfully disagree with you, Virginia.
Okay, all right, fair enough. Matt, good luck, and we wish you well.
Thank you very much.
Okay, thanks for calling in. I hope that was helpful. Where are you? Rob is in Rosanna. Hi, Rob.
Hello, Virginia. Hello, David.
Rob.
I've got a situation with my local owners corporation that we last held an AGM in October 2019, and since then they've issued 2 lots of 6 monthly fee notices with the fees from that AGM shown on them.
Yes.
Now, they've just issued the latest fee notice for the period commencing 1st of January next year, excuse me, and they've modified it. And when I've queried what the basis for this is, they've come back and said that they hope to get approval when they hold the AGM next year. And I'm just a bit confused. They seem to have reversed the burden for getting a change approved. They've changed the status quo and now demand a vote to revert to the status quo. Is what they've done legitimate?
What they've done is remarkably practical, Rob. If you were to not pay it, there's nothing they could do about it because it's the annual general meeting that fixes the fees.
Right.
So if they're...
You're typing out this answer, aren't you?
So, Rob, you would need to look at what last year's resolution was. If last year's resolution just fixed the fees for a year, well, they've been fixed and paid. So at the moment, there is no resolution in respect of fees for the current financial year. Your technical answer would be, in the absence of a resolution fixing the fees, I'm not going to pay any.
Right.
But that's not a particularly helpful outcome.
Look, I'm more than happy to pay the fees, but they just, as I dig more and more into this owners corporation stuff, it seems that altogether too often they ride roughshod over what is the proper processes.
We live in difficult times. I understand your position. Rob, I would turn around and say, you might choose to say, I'll pay last year's again until such time as the rate is changed by an owners corporation.
Right, fair enough.
I just wouldn't like to see the owners corporation go broke because everybody's taking the same approach.
Oh, there's no chance of that happening. It's a very, very large owners corporation covering hundreds of lots, so there's no chance of that happening. It's the experience I've had with different commercial owners corporation management bodies has been uniformly unsatisfactory in the way they cut corners and don't follow procedures, rules and acts.
I actually think that owners corporation managers don't get enough money for the work that they do, and so they cut the corners. Well,
they do more than cut the corners, in my view, and well, not just my view, my experience. But I take the point you're making, David. So thank you.
Right. Thank you.
Good luck, and good luck to you there. David in Thornbury's got a VCAT question. Where are you? There you are, David. Hi.
Hello. Thank you for your program. Just a query with a VCAT-related matter, David, if you will, please. I had a ruling in my favour, and the order was made in my favour against a gentleman who told me he was going to produce some goods that were sold on a well-known auction site, and didn't come through with the goods. And basically...
What was the order you got at VCAT, Dave?
To replace... it was basically to reimburse me, rather, for the cost of the item, and including the cost of the order, I believe, or the application.
The cost of your application. So you've got a monetary award?
That's correct.
Yeah,
That's
it's $100 or $1 or whatever it is. Right?
Right.
They will give you... There is a process on the VCAT website for getting a certificate issued by VCAT as to the amount of judgment or order. That then gets transferred to the Magistrates Court system, and you use the Sheriff's Office via the Magistrates Court to enforce the order.
That's what I'm not sure on, because I was told that I got the certificate, and they issued a certificate. I went to the Magistrates Court, and they said you need to go to civil proceedings on the Magistrates Court website, and there's a cost to get the sheriff involved. And I thought, well, this is just getting a little convoluted.
No, there is a cost to get the sheriff involved, but have you got your judgment registered in a magistrate's court yet?
Yes, I do.
Okay,
yes.
Then the answer would be you now have to pay someone to go out and enforce it.
So how do you do that part?
That's the sheriff's bit. That's where you go onto the Magistrates Court website and you follow the links to the sheriff's site and you pay them some money and they will attempt to recover the debt for you. And their costs.
Okay, so it's approximately $650. No, it's probably about $700 and a little bit over. And what would the cost of the sheriff's be to involve that service? Or
I couldn't tell you. The answer would be I'm beginning to wonder whether it's worth your while, David, to send a sheriff's officer out a couple of times.
Yeah.
And does the person have any assets that could be seized? Who knows?
Sorry, we can't take that any further for you, David, but good to talk to you. Mr. Whiting, nice to see you.
Nice to see you.
And I won't see you next week because I will be on leave, wrapping up at the end of this week to take a bit of a break, and I'll be back in the new year. But thank you for all your wonderful work this year, and we can expect to see you back in 2021, can't we?
Indeed. When? Do we know?
Yes, we'll be back on air broadcasting from, is it Monday the 18th of January, I think is the Monday?
Okay.
Monday the 18th of January. So you're on the Tuesday.
19th.
Yes. We'll see David Whiting. I'll see David Whiting on the 19th, but he'll be here next week.